Well, I have the honor of introducing our last panel for today. We have four distinguished speakers joining us, and let me just spend a few minutes telling you about each of them. To my far right, we have Eric Rappan. Mr. Rappan is a partner at Shepard, Mullen, Richter, and Hampton in New York City, where he practices as a labor and employment attorney. Mr. Rappan represents both domestic and international companies in a wide range of labor employment law matters in state and federal courts and a number of administrative agencies as well. His practice encompasses discrimination claims, wrongful discharge, employment contract and restrictive covenant issues, whistleblower, sexual harassment, and lots of other claims. Interestingly, he also represents clients in matters relating to the labor election process, something I know nothing about. And that includes election campaigns and also hearings before the National Labor Relations Board. Mr. Rappan graduated from Binghamton University, where he was magna cum laude, and also from Brooklyn Law School, also magna cum laude. Next to Mr. Rappan, we have Kirsten Kepsel. Ms. Kepsel is the Director of Legal Affairs and Tax at an aerospace trade association. Some of the issues that she's worked on include counterfeiting and piracy, which is how I've come to know her, insider threats, trade secret theft, and protection of data submitted to the United States government. Ms. Kepsel received an LLM degree from the Franklin Pierce Law Center. Prior to that, she worked for the Texas Manufacturing Assistance Center at the University of Texas at Arlington, and her work there focused on environmental management systems and improving manufacturing processes. She also worked for a number of years as an engineer. She worked both at General Dynamics and at Lockheed Martin Tactical Aircraft Systems. At those companies, she worked both in research and development and manufacturing in aircraft programs. Over on my left, we have Gerald Ferguson. Mr. Ferguson is the coordinator for the Intellectual Property, Technology, and Media Group at Baker Hostetler in New York. And he's also the national co-leader of Baker Hostetler's Privacy and Data Protection Team. Mr. Ferguson has assisted a wide range of businesses in developing intellectual property protection and monetization programs. His clients have included financial institutions, internet service providers, and also apparel companies. He's a regular contributor to Baker Hostetler's Data Privacy Monitor blog. He regularly lectures before industry and continuing legal education groups, and he's also the co-chairman of Intellectual Property Committee of the New York Bar Association International Section. Mr. Ferguson graduated from the University of Virginia, and he received his law degree from the University of Virginia School of Law. And on my far left, we have David Jacobs. Mr. Jacobs is Consumer Protection Counsel at the Electronic Privacy Information Center. His work focuses on representing consumers' privacy interests in front of Congress, the courts, and also federal regulatory agencies. Previously, Mr. Jacobs worked at the United States Department of Justice, at the American Civil Liberties Union, and also with the United States Senate Subcommittee on Antitrust, Competition Policy, and Consumer Rights. Mr. Jacobs is a graduate of the University of Wisconsin-Eau Claire and also of Harvard Law School. And while he was at Harvard, he was involved with the Cyber Law Clinic at the Berkman Center for Internet and Society. So we have four wonderful speakers with us. Let me just take one more minute to give you some idea about what they're going to talk to us about today. You already know the topic of our panel is privacy, employment, and contracts in social media. Earlier this morning, when Professor Suggs introduced his panel, he took kind of a quick poll among the participants in the audience, and he asked you some questions about your social media practices. I can't remember if he asked this question or not, so let me ask it. When you signed up for Facebook or LinkedIn or some of these other social media services, how many of you actually read the terms of use and the privacy policy associated with those sites before you joined? Oh, we have 2 hands. And how many of you have monitored the changes in the terms of use and the privacy policies associated with your social media services? Well, some of the questions that I hope our panelists are going to address this afternoon are, what are your rights under those agreements? And particularly, what privacy rights do you have as users of social media? What rights do you have with respect to Facebook, to LinkedIn, to all of these other services, and how do they vary? How do they change over time? More importantly, when can employers or prospective employers access information on social media sites? And what can they do with the information that they access? Can they use it to decide whether to offer a job to a prospective employee? Can they use it to somehow penalize existing employees or to promote them? And what about the government? When can state government or the federal government access your private information on social media sites? And what can the government do with it? What can the courts do with your information that might be found on social media sites? Troubling questions, right? What about data security breaches? That's another thing that we hear about. Do data security breaches really happen in the first place, or is this just something that the papers, pump up and tell us about, but it's not really much of a concern? And if they do happen, what kinds of information gets compromised when those breaches take place? How are users damaged by those data security breaches? Well, those are just a few of the questions that I'm hoping our panelists are going to address. And at this point, I am going to turn things over to Mr. Radpan.
Thank you very much. I am an employment lawyer, so we're going to talk about issues related to labor and employment and how the social media impacts that. What's interesting about this is I don't have a Facebook account. I don't have a Twitter account. I don't know what the terms and conditions of those media have to say. And yet I find myself speaking more and more about Facebook and Twitter. And the reason is because I know about those media avenues with respect to how it affects the employer and employee relationship. And up until about a year ago, we would get questions from clients, what can I do with a prospective employee's social media? What can I do with a current employee's social media? Comments that they make, photos that they post, people that they like or dislike on their social media accounts. What can we do with that information? And there was never a clear answer. There was never a bright line answer. And in some areas, there still is some gray area. But 2 areas that I want to focus on are, what, if anything, can an employer do with respect to accessing a prospective employee's social media account? Because there has been some clarity on that. And also to talk about what can an employer do when they learn about comments that an employee makes in social media, whether it be on Facebook, Twitter, what have you. With respect to the latter topic, the best way to go through it is to go through some case studies that are based on, that are real cases. And I'll just ask for a quick show of hands after each hypothetical just to get a feel about whether or not you think the employee's termination was lawful or unlawful. And no one's grading you, so put the hands up, okay? But let's start with the first topic, which is what can an employer do when meeting with a prospective employee and wanting to access their social media account. As I mentioned before, there was no clarity to this issue until about a year ago when there was a case that came out of the state of Maryland. And it involved a corrections officer who used to work for the Maryland Department of Public Safety and Correctional Services. He left employment after his mother passed away and then decided he wanted to come back to work. He had resigned. In other words, it wasn't a job-protected leave type issue. He had left. But he wanted to come back, so he had a re-interview for his position. And in connection with his interview, he was ordered to turn over the passcodes to his Facebook account and his other social media accounts. And feeling like he had no choice, he turned it over. After the meeting, he felt very uncomfortable, and so he went to the ACLU. So Mr. Jacobs may have some I know it's not in your area of expertise, but you may know something about this case. He went to the ACLU, and the ACLU felt, as frankly I do, that there's something inherently unfair about an employer demanding, and I represent employers, but there's something inherently unfair about requiring a prospective employee to turn over access to their social media account. The Maryland Department of Public Safety had said, look, he's going to be working in a prison. We all know there's a lot of gang activity in prisons, and so we need to know whether or not he has any affiliations with any of these organizations, is friends with any one of those organizations, because we can't have him monitoring a prison if he has certain allegiances. However, once the ACLU got involved, the Maryland Department of Public Safety backed off, and then Maryland became the first state to pass a law prohibiting employers from demanding access to prospective employees or current employees' social media accounts. So if you work in the state of Maryland and your employer demands access to those accounts, you don't have to turn them over, and they cannot retaliate against you for not turning it over. In other words, they can't say, well, since you're not turning it over, we're going to let you go. They cannot do that. So Maryland was the trendsetter here. Other states have quickly followed suit. A variety of states, if the bio didn't give it away, the accent will give it away. I am a New Yorker through and through. The state of New York has also worked on passing one of these laws. The state of Illinois has also moved forward in passing one of these laws. And some of the states have unique wrinkles to the law. So, for example, Illinois says not only can you not demand access to the employee's Facebook account by demanding the password, you also can't require them to pull up their social media account for you to view it. In other words, where you look away, they type in the password, and then you get to look at everything. That also is prohibited in Illinois. And frankly, I think it'd be prohibited in any of the states where these types of laws have been passed. California, which is a notoriously anti-employer state, actually included a safe harbor provision in its law to say that employers can't be sued for negligent hiring if they don't access an employee's social media account. The concern was, someone applies to work with us, we don't do the due diligence of going through their social media account. It turns out that they were homicidal, and they had threatened several people on their social media account. We hire them, and the first day they come to work and kill somebody. And then there'd be a negligent hiring claim against the employer. Well, California said, no. We understand we're not letting you access those accounts, and we're also going to create a safe harbor for you that will immediately lead to dismissal of any negligent hiring claim. So in addition to New York, California, Illinois, Maryland, Delaware, Michigan, Minnesota, New Jersey, Texas, and Washington have all taken steps to try and pass similar laws. Especially in the employment context, you learn pretty quickly that some states move quickly when employee rights issues come up, some states move slowly, and some states don't move at all. So I think you'll see some more states that will pass these types of laws, but there are a lot of states that probably won't address the issue at all, which leads to the question of what has the federal government done to try and protect employee rights in this avenue. And the federal government has looked at two separate bills that both try to accomplish the same goal. One's called the Social Networking Online Protection Act, and one's called the Password Protection Act of 2012, both of which are designed to prohibit employers from accessing prospective employee emails, social media accounts, which I guess would include their email accounts, and also prohibiting employers from demanding access to those accounts. In addition, Senators Richard Blumenthal of Connecticut and Charles Schumer of New York have requested that the Department of Justice and the EEOC launch federal investigations into this type of practice and create their own set of prohibitions, but those steps have not yet been taken. So that's really, in a nutshell, what the law is today on employee and prospective employee rights with respect to their social media accounts. As a quick aside, this doesn't necessarily mean that your use or your access of your social media account from your work computer is completely protected. But for example, we always advise our clients when you roll out a handbook or even as a standalone policy, you have to make it clear to the employees that they don't have any expectation of privacy in their workplace emails, meaning, company.com, personal email that they access on our computers. In other words, we have the right to monitor your computer activity. And if you choose to go into your Gmail account while you're at our computer, and we happen to be monitoring your computer at that time, we have the right to review whatever you pull up on our computer. And in New York, provided your policy is clear enough, you would be allowed to do that. That doesn't mean you can steal their password, go into their account when they're not there, their personal account when they're not there, and go through their emails. But if you're monitoring their computer and they pull up their Gmail account and they have emails on there that you can see by monitoring the computer, you are free to read them. In fact, there's even a dispute in New York about, okay, well, what if I pull up my personal email account to email my personal attorney about how I want to sue my awful employer? And in New York, and states vary on this as well, in New York, the answer is, if your policy is clear, that if you choose to use our computer to send an email to whoever, and we happen to be, again, keep in mind, the concept is we happen to be monitoring your computer at that time. We're not surreptitiously stealing a password and going into your personal account when you're not here. But if you choose, and we happen to see it, we have the right to review it. Any privilege between you and your counsel is waived. So don't go to your employers, for those of you who are in school a few months from now, and start thinking you're safe to email all your friends about how awful everything is at work. Okay, be careful about that. I don't want you calling me and saying, you told me I could do this. So keep that in mind. The other issue that I want to discuss is what can employers do, what rights do employees have to comment statements that they make in social media. Now, I can tell you that until this whole wave started to try and figure out what employees' protections are with respect to their use of social media, employers, would terminate someone at the drop of a hat for saying the wrong thing at the wrong time. And a lot of employers still do that. What employers need to understand is that it's not so black and white. There's a lot of gray area. And the gray area is created in large part by a lot of decisions that have been issued by the National Labor Relations Board. Now, I don't know if any of you have taken labor law here or not, but I'm not going to bore you with too much detail. But the National Labor Relations Board is a federal agency that's in place to enforce the National Labor Relations Act. The National Labor Relations Act is a law that helps to define what goes on between mostly unionized employees and their employers, but it also covers non-unionized employees who have the right to engage in what's called protected concerted activity. And that just means two or more employees discussing work conditions at its simplest. So I have about 5 minutes to go. I want to run through just a couple of examples and see what you guys think. There's a bar. Bartender notices that one of her coworkers is, instead of using the top shelf liquor, is using some knockoff liquor to make the drinks. Okay, she's outraged by this. She knows that the owner sees it. She goes home and on her Facebook page writes that a coworker of hers is screwing over customers, that dishonest employees and management that look the other way will be the death of a business. Okay, someone sees that, reports it to her employer, she gets fired. Quick show of hands, would the termination be upheld? Yes or no? Yes, you think the termination would be upheld? Okay. It seemed like the majority of the room, and you guys would be correct. And the reason is there was really no protected concerted activity there about her working conditions. Okay, she didn't like what a coworker was doing, but it wasn't as if she was complaining about her wages, her working conditions. It was really about some unethical coworker who was trying to, in her words, screw customers out of the full value of what they're purchasing. I'm going to try and get to a couple of the good ones. Here's one of my favorite ones. 5 employees work for a nonprofit. They engage in the following Facebook conversation about their jobs, managers, and some of their clients. One of them posts, "A coworker feels that we don't help our clients enough. I've about had it. My fellow coworkers, how do you feel?" One of them responds, What the F? Try doing my job. I have 5 programs. Another one says, "What the hell? We don't have a life as is. What else can we do?" Another one says, "LOL, I know. Think it is difficult for someone that it's not. Think it's difficult for someone that's not here 24/7 to really grasp and understand what we do. Clients will complain, especially when they ask for services we don't provide. F her. Love you guys." Okay. All 5 of them get fired. What do you guys think? Who thinks that those terminations would be upheld? Okay, less than before. Your instincts are right. These terminations were deemed to be unlawful. And while the language that some of them used was not ideal, okay, the concept was they were talking about their terms and conditions of employment, that they had an overbearing manager who thought they were working too much and that they weren't being appreciated at work. And that's the type of conduct, that's the type of discussion that the National Labor Relations Board will protect. And this nonprofit was required to rehire all 5 of these folks and give them back pay. And, by the way, paid their lawyers to go lose in front of the National Labor Relations Board. So it was a very expensive mistake that the nonprofit made. The last one I'm going to give you, and if we have time, we can go through some others. Car dealership. Car salesman works there. It's a high upscale car dealership. They have a meeting with sales managers and management to discuss rolling out the next year's models of cars, and they're going to have a big reception for their clients and customers. But the dealership decides we're going to serve hot dogs and water. We're not going to serve champagne or wine or anything fancy like that. One of the sales managers is outraged by this, can't believe it. How are we going to attract the clientele we need by giving them stale hot dogs and dirty water? And so he goes, like everyone else, to Facebook. And he posts a bunch of pictures from the event on his Facebook page. And he writes sarcastically, he was so happy to see that his employer went all out by providing small bags of chips, inexpensive cookies from the warehouse club, semi-fresh fruit, and a hot dog cart where clients could get overcooked hot dogs and stale buns. He also went on to say, along with pictures of a customer drinking something, he writes, "No, that's not champagne or wine, it's 8-ounce water. In this photo, Jim is seen coveting the rare vintages of water that were available for our guests." Okay, now, he also posted one other photo of a car, and then that same car totaled. And he wrote, this is your car on drugs. And what had happened was a customer had come in with his son to check out an SUV. They put the son behind the wheel. The son hit the gas, went flying off the lot, into a tree, into a ditch, totaled the car. So he posted that along with the sales event photos. He was terminated. Who here thinks that the termination, based on all the facts I gave you, is a justifiable termination, at least under the law? Okay, now you guys are right, but here's why you're right, and this is an important distinction. Had he only tweeted about the sales event, and the board said this, the termination would have been unlawful. Those are about, he's a sales manager, he's trying to make money, these are about terms and conditions of trying to woo customers, and he would have been justified in posting those, which is surprising because I'm sure the car dealer owner would have been outraged over that alone. But by posting the photo of the incident that happened at the lot and finding it funny that a teenager totaled one of their Jeeps on their property, the board found that that's what the employer said they fired him for, probably because their lawyer said, you better figure out a reason other than the sales event to have fired this guy. The board bought it, and they said, because you fired him as a result of this other incident and him posting about that, that termination was valid and was upheld. So I know my time is up, but just some things for you guys to think about in terms of what your rights are with respect to social media and your employers.
Thank you. Our next presenter is Kirsten Kepsel.
First of all, I want to thank you all for inviting me today to speak. It's fun to get out and hear other people's points of views on some of these topics, because sometimes for those of us who work in it, we end up focusing on very small areas. And I know they asked earlier, like, how many people used Facebook, Twitter, Instagram, or Pinterest? And then Ms. Campbell asked how many people had actually read the terms of service. And now I'd like to ask a third question. How many of you were truthful when you actually signed up for the social media? You told your real birth date, the real year you were born, where you're located, and if you're on some dating sites, your actual height and weight and description of yourself. So how many people were actually very truthful when they signed all those things up on social media? Really? So, okay. I want to just kind of start out with some of the statistics for social media. There's actually someone online that tracks this, and you can almost get week-by-week statistics on who's visiting what social media websites. They also track what terms are trending. Like if you're looking for searches online, they put in the words saying who's actually, what words are being searched for. So for the week ending March 30th this year, Facebook had over close to 2 billion site visits. And this is 57% of the visits that are online. And then YouTube, which was next, 880 million. And then it kind of falls off from there down to Twitter, Pinterest, and Instagram, which for all the, to me, all the tweeting that goes on and all the Instagram photos that are posted, that this would be actually much higher, but from the statistics, it doesn't show that. Okay, and then if you can go, and I actually tried to find some of the other social media websites to look at what statistics they have, and this was Facebook's, that they now have 1 billion monthly active users as of last December. But what I find actually fascinating is in the next part, it actually turns up that only because it'd be 18% of monthly active users are in the US and Canada. Everybody else is around the world, which I would have thought it would have been a lot different, that you'd have more people from the US and Canada, which could also raise some questions with regards to copyright, because some countries around the world have a little bit different copyright laws. So this could have a huge impact on what you're putting up there. And for people that are in technical areas, are you actually posting something up there that could violate export control laws in the US? They talk about they have 618 million daily active users, and then about the same 680 million monthly active users using the mobile products. So if you go to a website and you want to be part of it, you basically have to sign up to the terms of services. You have to provide them information. You click the accept. Some people read it, some people don't. And then you get access to the website. But what's interesting is that I've really started thinking about these. Facebook calls it an agreement, although if you really look at it, it's more of a contract. In fact, what's interesting is Pinterest does actually call it a binding contract. This is actually part of their terms of service. Facebook says you agree to the statement. And oh, by the way, we will be updating it, and it'll be up to you to follow it. I mean, most people in the business world, if you went to buy, say, an automobile or anything, you sign a contract, and that's the way it stays. But online and social media, they can basically change that contract or agreement every single month if they want to, and it's up to you to follow it and see what they're talking about. So basically, you have this agreement, you sign up to it, it's very one-sided. Quite frankly, it's all to the benefit of the social media websites. It's certainly not to your benefit. So when you sign up, say, to Facebook, you get the right to post photos, send emails, do the timeline, etc. But what does the social media websites get? I really almost look at it anymore as a way to make money off of you signing up. Because they're going to take all this data that they've collected, because believe me, they are collecting data from you, no matter what people like to think, they are collecting data, they put it together, and they're providing it to the advertisers. So I don't know how many of you ever noticed you are on a website. You might be on Facebook, you might even be on Google, you might be on eBay, whoever is having advertising, and you click on something, and then all of a sudden those ads will start showing up every single time you go to other websites. Those ads will always be there. They'll keep track of like what websites you have gone to. And to really understand what is collected by these websites is that, I don't know how many of you remember the Boston Craigslist killer from a few years ago. Well, the Boston Police Department went to Facebook and served a Freedom of Information Act on the Boston Craigslist killer. They then released the information that they received from Facebook publicly, made it available publicly. The Boston Phoenix newspaper decided that they would publish what was on there. Even they were astounded by the amount of information that was made publicly available, and they even redacted some of it themselves because they did not feel that they should publish it out there. And I'll tell you some of what they asked for, because this is actually on the internet. You can look for Boston Phoenix and the Craigslist killer and what was posted. They basically asked for the complete online profile and posted files, include blog notes, notifications, comments, all wall-to-wall conversations, any photos, name, address, personal information, all subscriber contact information, all internet protocol logs, the length of service, their friends lists, and any private messages in the user's inbox, trash, and sent mail. So that's basically what Facebook has access to you when you sign up for those pages. But also, you have to consider that when you sign up to either Facebook or Pinterest or any of them, you've also given basically a royalty-free license to Facebook to use any IP content that you post on it or in connection with Facebook. They can use it however they want. If they wanted to sell it to an advertiser to use in their advertising, it's a done deal. You gave them the right to do so. I mean, if you look at some of the famous photos that have been out here, imagine if they were posted on Facebook and all of a sudden you have some advertiser saying, wow, that'd be a great photo for our product. We're in an agreement with Facebook, or Facebook goes and says, hey, here, Mr. Advertiser, why don't you take this photo? And then with Pinterest, they basically, you allow Pinterest and its users, it's not only Pinterest, but also any of the users on Pinterest, to be able to take your photos that you put up there. They can use them, store them, display them, reproduce them, repin, modify, and create derivative works, perform, and distribute them. On Pinterest, they said solely for the purposes of operating, developing, providing, using in Pinterest products. And for those of you who didn't read the original terms of agreement, they actually had it in their original terms when they first came up that when you posted any photograph on Pinterest, any of the users could print it out for their own non-commercial use, except what is non-commercial use. And I'm really surprised that they did not have some IP attorneys to look at their agreements before they ever even put them up there. But they've since modified it after a lot of outcry. So then we get to violation of the terms of the agreement. So what actually does happen if you don't tell the truth when you sign up? What if you lie about your age on Facebook? But Facebook says you will not provide any false personal information on Facebook. You won't create an account for anyone other than yourself without permission. Craigslist has a statement that what if you use a different description on Craigslist other than what the item really is. Craigslist said you shall not use false or fraudulent content, including but not limited to false, fraudulent, or misleading responses to user ads transmitted via Craigslist. And then what about letting a friend log into your Pandora account? And a lot of them really say this: you have a responsibility for maintaining the confidentiality and security of your account, and you will agree that you will not allow others to use or access your account. And actually there's been some discussion that there are prosecutors around the country that could and would prosecute writers of untruths under the Computer Fraud and Abuse Act, which makes it illegal to access a computer without authorization or in a way that exceeds authorization. And there actually has already been one case on this, U.S. v. Drew. Lori Drew was charged with violating the Computer Fraud and Abuse Act. She used a fictitious name and her age on a MySpace account, and she basically was using that account to make hurtful comments to a teenage girl. And unfortunately, that girl took her own life. But the federal prosecutors were claiming that Drew broke federal law by violating MySpace's terms of service, and that MySpace Communications were responsible for the girl's death. Electronic Frontier Foundation argued that criminal charges for terms of service violation is dramatic misapplication of the CFFA with far-ranging consequences for computer uses. And in fact, there's been a recent case, U.S. v. Nosal, and in part of the description, they talk about people violating the terms of services. Under the government's proposed interpretation of CFAA, posting for sale an item prohibited by Craigslist policy, or describing yourself as tall, dark, and handsome when you're actually short and homely will earn you a handsome orange jumpsuit. Not only are the terms of service vague and generally unknown, unless you look real hard at the small print at the bottom of the web page, but website owners retain the right to change the terms at any time and without notice. Accordingly, behavior that wasn't criminal yesterday can become criminal today without an act of Congress and without any notice whatever. And then finally, lying on social media websites is common. People shave years off their age, add inches to their height, and drop pounds from their weight. The difference between puffery and prosecution may depend on whether you happen to be someone an AUSA has reason to go after. And so finally, I'd like to end with, so what do? Read before you click accept. I am actually one of those people that read, and my brother makes fun of me for actually reading them. I read all the software ones, and I actually went through and read Facebook's, and after I read, I said, no, thank you. And also watch what you post, because it may come back to haunt you. Thanks. There you go.
Thanks, Kirsten. Our next speaker is Gerald Ferguson.
I'm going to be speaking this afternoon on two topics that did not exist when I was in law school 25 years ago: privacy and social media. Social media for us was hanging out in a friend's living room watching LA Law, and privacy was a subsection of your torts class that was covered, if at all, in maybe half a day. Now, privacy is a separate discipline, and I lead our firm's privacy team, which many firms now have, a national privacy team. It's an important part of the practice of the law. And I think that timing here was very good for me to be following Kirsten, because I'm going to be asking the question, what are the legal limitations on social media sites in terms of what they can collect and what they can do with your information? And I'm going to ask us to answer that question through a lens. I'm not one of these people who thinks that it's bad that all of our information, it's per se bad that all of our information is being taken by social media sites. We get these sites for free. They're fun, and if it's LinkedIn or even Twitter, it can be very professionally helpful. We're getting it for free. What are we giving? We're giving our personal information. I'm okay with that if it's a negotiation and an exchange on an even playing field where both parties understand what they're doing. I'm not sure, and I think this was Kirsten's point, that that's really what's going on. And my question today is, does our existing legal framework help create that level playing field? And I have a huge slide deck. There's no way I'm going to be able to cover it all, but it is going to be posted on the website. And so some of these slides I'm just going to be racing through. If you have any questions, maybe we can talk after. You can email me, read my blog and comment, follow me on Twitter. I follow back. I'm happy to answer your questions however you'd like to do it. So very broadly, I'm going to be looking at the sources of privacy law, because there is no privacy law per se. There's a hodgepodge of laws created for different purposes that all impact privacy on social media sites. I'm going to talk a little bit about breach notification and the breach of a social media site and what that might mean and what happens then if there's a security breach. And I've Finally, I'm going to address the sharing of consumer information issues that Kirsten was talking about, seeing what sort of legal limitations, if any, there are there. And finally, if there's time, maybe after David's gone, we'll talk a little bit about what we see as the emerging issues. So in terms of the sources of privacy law, you've got federal law, you've got state law, you've got industry self-regulation, which is very important in this area. You've got to be aware of foreign law, and contractual obligations are also very important. The federal laws, you have the FTC, which is kind of the broad overseer saying, don't be unfair, don't be deceptive. You have industry-specific statutes focused on financial, healthcare. You've got statutes focused on specific issues like children's privacy, and then there are other issues relating to more broader issues of cybersecurity and infrastructure. But it's a hodgepodge, and at times it's even contradictory. Under the state laws, the most important development is the breach notification laws. As someone practicing in the area of privacy, that's most of what I do. Help companies respond to privacy breaches, and I'll explain a little bit why that is today. There also are certain states, such as Massachusetts, that have gone a little bit farther in trying to provide additional protection for personal information. And then there is still the common law background of invasion of privacy and misappropriation of someone's identity for commercial purposes. And frankly, the social media sites are immune there. They've got a statute that says they're not immune for what you and I do, violating one another's privacy rights. That's the Communications Decency Act. But we can be held liable. So be careful, especially for, not that an individual is likely to be sued, but when corporations set up Facebook pages and their own LinkedIn pages, be careful, because you could be held accountable for violating these statutes. Industry self-regulation, where that's particularly relevant to what we're doing here. The payment card industry rules, many people think they are a statute. Very detailed selection of rules regarding credit card collection. The Network Advertising Initiative rules on the collection of cookies, what Kirsten was referring to, how you say, you know, I like the Caribbean on one website, and then the next day you get an advertisement for a Caribbean vacation every page you go to. Those technologies, they are primarily governed by industry self-regulation and the Network Advertising Initiative standards. You also have to be aware of foreign law. The big picture point I'll make here is that there's a fundamental difference between the European approach to privacy and the US approach. European, really from the backdrop of totalitarianism and the abuse of private information by totalitarian regimes, is very focused on privacy as a right, where our FTC and in the United States, it's much more of, we're trying to promote the free market, we're looking for free market solutions, so it's looked more as an exchange of information, which is to some extent the lens I'm suggesting we look at these issues through. If you are interested in international privacy law, we do have a compendium of all of the significant laws on our blog, which you can look up if you're interested. And then I can't, again, underestimate the importance of contractual obligations. The privacy policies are a source of rights, and although they're very favorable to the companies, they do give us some rights which are sometimes enforced. I will also just pause and say that because there has been so much regulatory focus on Google, and because anybody who's in the space of doing behavioral advertising, working with cookies, is dealing with Google, Google has come up with their own guidelines which are really quite influential in terms of company practices. So what is personally identifiable information? That's really where a lot of our focus has been on protecting that information. And there are a lot of definitions out there, but I think the way you think about it is this information that can be used for identity theft? And then there is certain information, such as religious belief, political affiliation, which is accorded higher protection, particularly over in Europe. So the important point here for social media context, personally identifiable information is not publicly available information. So if you're broadcasting stuff on your Twitter and your Facebook pages and you're not restricting access very carefully, it's not PII anymore. And confidential trade secret information, we're not really dealing with that in our laws right now. That's why President Obama issued his cybersecurity directive, which she announced at the State of the Union, and that there's a lot of desire for a national cybersecurity law, but we really don't have laws that are focused on protecting our critical cyber infrastructure. Everything's focused on identity theft right now. So the first issue I do want to focus on is data breach. And again, I'm going to deal with this briefly, but I'm telling you this is the hot area in terms of where the practice is right now. I'll talk about the notification obligations, cost of compliance, and then the class action issues. But again, I want to look at them from the lens of, is this framework supporting and promoting a negotiation on an even playing field between the social media sites and the consumers when we give up our information? June 2012, a 6.5 million LinkedIn passwords are posted on a Russian hacker forum. Yes, there are such things as Russian hacker forums. Why do Russian hackers have forums? Well, of these 6.5 million passwords, roughly 60% of them had already been decrypted, and the hacker was looking for assistance from other hackers in decrypting the other 40%. And the reason why so many have been decrypted is basically LinkedIn was using circa 1995 encryption technology. They really were using the most basic encryption technology that was available. LinkedIn password, is that PII? Most statutes, again, the focus on the statutes is information that can be used for identity theft. Well, there is, and one of the problems with social media passwords is that many people, their social media password is also their bank password, it's their stock, it's their E-Trade password. The fact that we, for ease of memory, will use the same passwords across sites, the fact that you've used this password on LinkedIn could be used to crack some of your financial accounts. And also, the information on your social media sites is a treasure trove for identity thieves. So this information was arguably under the statutes. It was a huge embarrassment for LinkedIn. It comes out that they don't even have a chief information officer or a chief information security officer. They're still operating as a startup when it came to security, even though they were a huge multinational company. So what does that mean? We've got data breach laws in 46 different states. And basically what these statutes require you to do is to notify the affected individuals, notify the regulators. The costs of response are very high. I got an example of just in notifying people and providing credit monitoring for 2 million records, it's about 2 million for the notification, another 5.5 million for the credit monitoring. So this often leads to class actions, and that also gets very expensive. And there's a lot of theories that the plaintiffs use for class actions, but they generally get tripped up on the standing issue. The courts say, yeah, you may have had an injury here, but you don't have standing to allege a claim because you're just a potential risk of identity theft isn't enough to give you standing. And in fact, there was a LinkedIn class action, as there always is in these cases. They tried to be a little bit clever and get around the standing issue by saying, well, you actually violated the terms of use, and that has worked in other cases. They said, well, we're just acting on behalf of premium members. They paid more expecting to get good security, which was promised, and they didn't get it. Court said no, just in March of this year, saying no standing. And essentially, what it said was, you didn't really show that the class paid for additional security. So again, but they did pay with their privacy, and that's kind of the issue that wasn't discussed. Should they have gotten credit for that in terms of the private information they gave up to get the security that was being promised for them? Now, the FTC does put some limitations on this consumer regulation sharing that we're talking about, and they've done enforcement actions against all the big players in terms of basically engaging in information collection practices that are either deceptive because they contradict what's said in the terms of use or in some way unfair. And I also had to kind of flip through this side. There is a statute that imposes a number of significant rules for sites that are directed at children under 13, which is why Facebook and others generally don't allow preteens on the sites. We all know there's no 12-year-olds on Facebook, but They've set it up that way that to register, you have to lie about your age if you're under 13. So Google, for example, was hit with a significant fines from the FTC in 2011 by not giving accurate information by not following its own terms of use. It offered this new service, Google Buzz, shared information from Gmail to Google Buzz users, which they said they weren't going to do. FTC says deceptive practice, steps in and fines, so Google cleaned up its act. Well, 1 year later, the FTC comes back and says, you are, in fact, people are trying to set their browsers to avoid cookies, which are the pieces of code that collect this information that lets you track people across the web. People are trying to set their browsers to avoid cookies. You're defeating that without telling them deceptive practice again, and you called your cookies temporary cookies where they really were tracking long-term activity. Largest fine ever, 22 million. Hey, FTC really stuck it to Google. Well, a lot didn't really think so. I think Google was able to afford that 22 million. But as I said, they have been since then really imposing higher standards on the industry that's involved in behavioral advertising anyway. To take a different focus, take a different look at the European approach, and again, it's more a view of privacy as a right than a bargain for exchange. Facebook has been under a lot of scrutiny from the Irish regulators, and essentially as a result of all this, just to give one example, in Europe, you no longer have the tag suggest when you post a picture of a friend and people show up to suggest how that be tagged. You don't have that in Europe. We still have it because it's disclosed in the terms of use, and if you've consented to it, you're stuck with it. And again, the class actions are, I think, really the tool that we as a society try and use to monitor behavior in many ways. There's a lot of privacy class action going on. And the way companies are trying to get around the standing issue is by repurposing statutes that were created for other purposes, such as the Stored Communications Act, which was supposed to protect against your information being turned over to the government, but it's so broadly worded that some people have said, well, you violated the Stored Communications Act when you, Google, shared my information with an advertiser without telling me. And these statutory claims, they're not having the exact problem of the standing issue. There's general recognition that statutory claim can provide standing, but still what you're finding is the courts are, for the most part, dismissing these claims. And I'll just conclude by talking about the Del Vecchio Amazon case, where under another repurposed statute, the Computer Fraud and Abuse Act, which is really, again, supposed to protect against hackers, the claim was that Amazon was violating that statute by placing cookies on a machine without consent. And what the court said is, well, there's a $5,000 threshold, and people said, well, my personal information was taken without my consent. It's worth $5,000. The court kind of laughed at that claim and said, no, there's no basis for that. But that really, to me, goes to the heart of why our existing scheme is not adequate, because it's not focused on protecting our ownership rights in our information and making sure that a free bargain for exchange is taking place when we give up that information.
And our final speaker today is David Jacobs.
Do you know where this turns on? Is this? Oh, it's on. Okay, great. So first of all, thanks to the Journal of Business and Technology, and thanks to the law school for having me here. It's great to be here and to get the chance to talk to all of you. I'm going to cover three issues. The first is the intersection of what's called big data and social media. The second is facial recognition and social media, particularly Facebook. And finally, government access to social media data. Now, these are all enormous issues, and I won't be able to do them justice in such a brief amount of time. So I'll give kind of a broad overview, and then maybe we will have time for questions at the end of the presentation. So first topic, big data and social media. Now, the term big data has no clear definition. It originally referred to data sets large enough to require supercomputers to work on them. But now, with the rise of computing power, it is generally just applied to data mining techniques to discover correlations in large data sets. So the key is the connection between certain pieces of data, not necessarily why or the causality involved. In the case of social media, the relevant data set is your data, your likes, plus ones, address, your pictures, your friends, your posts, your messages, and so on. And so the question is, what inferences have been made using this data, or what inferences could be made? And a number of studies have looked at this issue. The Economist wrote an article last year that found that social media data could be used to predict creditworthiness. They found specifically that applicants who type only in lowercase letters or entirely in uppercase letters are less likely to repay loans, all of their factors being equal. So that might be surprising, or it might not be surprising, depending on the type of people that we see doing that. One other inference is job performance. So studies have found a correlation between evaluations, employer evaluations, and evaluations of Facebook information on traits like agreeability and intellectual curiosity. So job performance is another inference. And then just last month, a recent study found that many traits could be inferred from just your Facebook likes. For example, sexual orientation with 88% accuracy, ethnicity, 95% accuracy, age, 75% accuracy. Some traits were not predicted very well. Intelligence was only 39% accuracy, and happiness was 17% accuracy. So not everything is entirely accurate. What is the relevant law in this area? What law might apply? Well, as you just learned, there is no broad baseline federal privacy law, but there are a few statutes that could apply. In particular, the Fair Credit Reporting Act applies to any data that's used to make certain eligibility determinations. So credit, employment, insurance. This law would clearly cover the use of social media data to figure out creditworthiness, for example. And it gives consumers certain rights. You have the right to be notified when a determination is made. You have the right to access your credit report and to dispute errors and so on. One other potential law is the Equal Credit Opportunity Act, and this prohibits creditors from requesting certain demographic information from applicants, race, color, religion, sex, for example. So that could apply depending on the use. And then finally, I'll just mention the Federal Trade Commission's consent orders with both Google and Facebook. These prohibit both companies from disclosing non-public user information with third parties unless they notify you and obtain your consent. These consent orders are more a restriction on what Facebook and Google can do and less on what other players can do with your data, but they are relevant. So next topic is facial recognition, and we'll use Facebook as an example for this. So 300 million photos are uploaded every single day to Facebook. So they have a large database of photos, and these photos are all subject to Facebook's facial recognition feature. It's called Tag Suggestions, and it generates a face print based on the data, the face data in the photos, and it uses this to suggest friends of yours that might be in the photo if it gets a match. Probably the most interesting study that I've seen using Facebook and facial recognition was done at Carnegie Mellon, and this study involved the use of an offline anonymous face, so a face that you could get looking at any one of you in the auditorium. That face was taken and identified by comparing it to a database of faces gathered from social media. And then the researchers went even farther. They used publicly available data to predict the interests of the identified individual and to predict the first 5 digits of their social security number. So this is kind of the intersection of facial recognition and social media and the wealth of information that's just sort of available publicly on all of us on the internet. That involved students at Carnegie Mellon. It's not, to my knowledge, possible to just do that with a random person you see on the street, but we're getting there. So the relevant law with facial recognition, again, no overarching federal consumer privacy law. The Electronic Communications Privacy Act might apply in certain circumstances, and I'll talk about that next in the context of law enforcement. And then finally, you have the Facebook and Google consent orders, which cover photos. So those might apply depending on what Facebook and Google decide to do with your photos. However, there are a few state laws that cover biometrics, and this would include facial recognition data. In particular, Illinois and Texas both have biometric statutes, and these laws are similar. They generally require that a private entity must notify and obtain consent before collecting biometrics, and this includes, in both laws, facial recognition data. Washington also has a limited biometric law, but it only applies to the DMV and to what they can do with your driver's license photo. So the states are moving a little bit faster than the federal government on this issue. Finally, law enforcement access to social media data. I'll talk about 3 methods that law enforcement uses to obtain information. The first is simply looking at what's publicly available or asking you. The second is through the Electronic Communications Privacy Act. And finally, I'll talk briefly about the use of national security letters. So first, law enforcement can simply ask you for information using social media, and they do this. There was a story in Slate last week about the Boston Police Department cracking down on the indie music scene because it was causing problems with local nuisance ordinances. And so they would go to forums or other social media websites and ask people when shows were taking place in order to crack down on them. And my favorite example is a message that says, "Hey there, local P native here," I think that was a reference to Jamaica Plain. "What is the address for the local music show tonight?" So that's the kind of message that you might get. And you know, you may or may not fall for it. That one probably not. So they also look at your publicly available information. The Department of Homeland Security monitors social media. They have a list of Twitter terms that trigger the creation of reports, and some of these terms make sense. For example, recovery, organization, watch. Some of them make less sense. So pork is a relevant term. Cloud will trigger a response, and exercise. So that may or may not be relevant. So moving on to the Electronic Communications Privacy Act. This law regulates government access to stored contents held by internet providers. It was drafted and passed in 1986, and just to give you an idea of the state of the world, in 1986, Congress contemplated that an email provider might print the email out and then deliver it to you through the mail, which of course is not how it works, but there was a lot that they failed to anticipate when they passed the law. So, because they had no idea how this technology would develop, there are a lot of very strange and seemingly arbitrary distinctions in the Electronic Communications Privacy Act. The one that gets a lot of attention is the 180-day rule. So if you have an what's called an electronic communications service under the law, which is essentially any service that provides email or messaging. The message feature of Facebook, for example, would be a good example. If the message is stored for 180 days or less, the law requires a warrant. If it's older, if it's more than 180 days, no warrant. And this doesn't make any sense to us now, but back then it was a feature of how people accessed email, and you had to actually go download your messages and take them to your local machine. So if you didn't do that, then presumably you had less of a privacy interest in the message. But it gets even more complicated because the courts are currently divided on what happens when the message is opened. So when an email that is 180 days old or less and ordinarily would receive a warrant because of this, what happens when when you open that message? Some say that therefore it loses its protection and no warrant is required because an opened email isn't in electronic storage under the requirements of the law. Other courts say no, a warrant is still required because there can be copies of emails stored for backup purposes and therefore they are in electronic storage. And this issue is currently the subject of a cert petition in a case called Jennings, if you want to look it up. So that is a live open issue. And Facebook and Google have their own law enforcement compliance manuals, and both of them require more process than ECPA does. So Facebook, for Facebook, photos, videos, wall posts, and location information require a warrant under Facebook's own policy. And for Google, Gmail content, private YouTube videos, Google Voice and text message content, and private Blogger posts require a warrant. So finally, I'll talk about national security letters. These are the national security letter provisions exist in a number of statutes, and they've been used for several decades, but they've become more common after the passage of the Patriot Act, and essentially they are used to seek certain financial, phone, or internet records, not the content of emails or texts or phone calls, but they have certain provisions that make them the target for civil liberties groups and open government groups and privacy groups. First, there's a non-disclosure provision so that the recipient company can't say whether they've received a national security letter. And the judicial review provision is extremely limited. A court, you can challenge these letters in court, and the court can set them aside if compliance would be unreasonable, oppressive, or otherwise unlawful. And the court can also remove the gag order unless a high-ranking government official certifies that doing so would harm national security. Then that has to be treated as conclusive. Unless there's evidence of bad faith. But so that's an extremely narrow judicial review provision. Last month, a court in the Northern District of California found the use of national security letters to be unconstitutional because it was not narrowly tailored. They were not narrowly tailored to survive First Amendment scrutiny. And also this circumscribed judicial review violated the separation of powers. So that case will certainly be appealed to the Ninth Circuit, and it'll be interesting to see what happens.
My question relates to employment policies, and I would like to know what would be a good social media policy for employers relating to negative comments about the company, and specifically, how does enforcement work with privacy issues of not being friends with the employer and possibly finding out through third parties and so forth, and how all of those issues relate together?
Those are great questions. With respect to the social media policy, the National Labor Relations Board has actually endorsed a policy. They actually wrote one and said, this is the one that employers should use. The problem, and by the way, so we advise clients, we take the NLRB policy, we tweak it a little bit, but that's the policy that we use. And the policy is very neutral. I mean, it prohibits you from doing certain things like divulging confidential information, trade secrets, internal information about the company, things of that nature. But it really serves more as a guide to the employee about things to think about when using social media. The problem with the board's policy is that when you read some of the board decisions, you kind of question why they would allow certain things in the policy to withhold their own scrutiny. For example, broad prohibitions on discussions about terms and conditions of employment are prohibited. But some of the guidance that the NLRB policy provides, you could point to an NLRB case and say, well, if I had this in my policy, the NLRB would say my policy's facially invalid. So there is a policy out there. That's a policy we use. I expect it to continue to be revised by the board over time. And again, it's less of don't do. It's more, when doing this, think about the following. So that's to answer your first question. With respect to getting information through third parties, that also delves into some ethical issues as well. So for example, at least in New York, an attorney couldn't try to friend somebody on Facebook under false pretenses or even without affirmatively disclosing who they are in an attempt to get friended and then get their private information. However, if a friend of someone on Facebook happens to work at the entity and delivers that information to the entity, there's nothing wrong with the entity reviewing it. Again, what the entity can do with it depends on what specifically was said in the Facebook account. But employers can't ask an employee, hey, go friend so-and-so on Facebook and tell us what they have to say. But if someone comes to the employer with that information without being asked to do so, the employer can certainly review it. And then you just need to think about, is this the type of statement that we can use to terminate that employee, or would be running afoul of their Section 7 rights under the NLRA?
Any other questions? Oh, here we have one.
So earlier you said that shoulder surfing in Maryland probably wouldn't be allowed. You assume that. Can you explain your rationale behind that and why an employer, I realize an employer under Maryland law couldn't ask for your username and password, but could they simply ask you to friend them on Facebook? And why would that be illegal if it is?
I missed the beginning, the first thing that you said. That's something I said earlier.
Yeah, no, you said earlier that shoulder surfing in Maryland where...
Shoulder surfing, right, got it, okay.
Yeah.
So why do I think that that's the case? The intent behind the law is to prohibit employers from inserting themselves into the private social media account of a prospective employee or an employee. To me, shoulder surfing, which frankly I'd never heard that phrase before, but it makes sense, shows you how little I know about the actual mechanics of this stuff. Shoulder surfing to me totally flies in the face of the point of the law. In other words, saying to an applicant, I'm not going to look at your password, but open it up and let me surf through it, to me is the same thing as demanding the password. And so I would advise an employer in Maryland to be very careful before doing that, because I think you fly in the face of the intent of the law. And I think just what happened was Illinois came after Maryland, and Maryland broke the ground, and I think Illinois said, hey, there's this possible loophole out there, let's affirmatively address it in our law. But I'd be shocked if an employer in Maryland would not be found to have violated the statute by shoulder surfing, at least the intent of the statute. Was that the whole question, or was there? Yeah, so, again, friending someone on Facebook, there's a lot of pressure in the workplace, okay? Supervisors can insert all sorts of pressure upon their subordinates. And so if you go to an employee and say, I want you to friend me on Facebook, and then you use that information at a later date to terminate that employee, I think the employee would have a fair argument to say, I had no choice, I was forced into allowing them access to my Facebook. Similarly, there was a case that involved Houston's restaurant where a manager, a waiter or a waitress had posted some negative things in social media. The rumors started flying around. A manager went to another waiter or waitress and said, go friend them, for the sole purpose of then telling me everything that's being said. And then they used that information to terminate that employee. And again, the question is the access and protecting the privacy rights of someone who has social media. On one side, you say, well, look, you chose to friend that person, and so everything you posted on there, you intended for them to see, and they could do what they wanted with it. That was one argument. The other side was, yeah, why did that person become friends with the first person? Well, because their boss told them to. And so there's that delicate balance there.
So what kind of due diligence is required by employers now?
Well, there's, with respect to social media, short of, Googling their name and seeing what's public, okay? But public Facebook, I have no problem looking at someone's public Facebook profile. Again, you got to be careful from an employer's perspective. From a simple discrimination standpoint, let's take sexual orientation. You interview somebody for a job, you decide not to hire them, okay? You're not, at least in New York, you're not allowed to ask them what their sexual orientation is, so you hire somebody else. You have no idea what their sexual orientation is. They sue you for discrimination for a failure to hire claim, and one of your key defenses is, we had no idea what their sexual orientation was, so how could we have had any discriminatory animus? Well, if you've now searched their Facebook page, you may see a photo with them and their partner, you may see statements from them, you may see them liking certain LGBT communities, activist programs, things like that, that would make it clear to you, okay, I know what this person's sexual orientation is, so that defense goes out the window. So I don't think there's an affirmative obligation on employers to really do anything. And the problem is, I've had clients who looked things up. I had a client who called me and said, we have this prospective applicant, it turns out that she's a dancer for rap videos. And there were photos of her. This is why I love my job, by the way. This is like great fact patterns that come up every day. She was a dancer for rap videos, and they said, well, now what do we do? Now we have all this information, there are all these photos of her, she's going to be the talk of the office. And, my response was, well, first of all, why'd you bother doing that search? Because now you put yourself in this position. But the mere fact that she engages in lawful activity as a dancer during her free time is not a legitimate, valid reason in New York to not hire somebody. So now you've kind of, if you don't hire her, you've opened up a can of worms. The question becomes, was she otherwise qualified for the job? Would you have hired her if you hadn't seen that? Yes, then you have to hire her. Or find some other reason that you think will withstand scrutiny. So at least in New York, my advice would be, you don't really need to do any due diligence search. Some clients insist on it, and my advice is, okay, then come back to me and tell me what you found, because we need to be very careful before we make decisions with respect to that candidate.
One last question.
Forgive me if this question isn't very pointed, but I'm curious if some of you can speak to the implications for privacy for when you open an account and you make it public, but then you subsequently, after posting something, make it private or delete it, or what happens then? What are the privacy implications, and to what extent is it open and to the public and not considered private information, despite the steps taken next to try and protect yourself?
That's actually an excellent question, because it's a very hot topic in terms of where privacy law is going and the whole issue of the right to be forgotten. The reality, though, is that in the United States right now, you've got the rights that you are granted in the policy of that entity that you signed up for. And Facebook, for example, says, well, we'll put that information in a place where other people can't see it, but they're not committing that they're going to get rid of it. Europe, with its new privacy directive that was going to be voted on this month, that's now been pushed back to next month because it has a lot of controversial elements of it, is promoting this idea of a right to be forgotten, the right to essentially erase your presence from social media. But that's controversial too. I mean, you know, Kirsten and I take a picture with Eric, and we all consent to the picture being taken. I post it on Facebook. Eric decides a year later he wants to be forgotten. He doesn't want any pictures of him on Facebook, but I like that picture of Kirsten and me. You know, and so whose rights, whose choice is going to be honored there, particularly where there was consent to it being posted in the first place? That's where that issue is being debated right now.
Let's thank our panel one last time.
I would also like to thank our panelists for their presentations and all of our moderators, including Professor Campbell, for their assistance in developing a lively conversation today. To provide a summation to the discussion that we've heard, I'd like to introduce Julie Hopkins. Julie is the Intellectual Property Law Program Manager here at the University of Maryland Francis King Carey School of Law. She graduated from Smith College with a degree in biology, and she graduated from our school with honors, and she now oversees the academic advising program for the IP Law Program. And she notably organizes the fortnightly IP speaker series here at the school, which brings in speakers to discuss current intellectual property issues. Ms. Hopkins is in high demand across the IP program, as she is able to aptly apply her private practice experience from Palmer Cooper Hopkins to her work with law students. Please join me in welcoming Ms. Hopkins.
Thank you, Claire. I recognize the only thing standing between you and the opening day Oriole game is me, so I'm going to make this relatively short. First, I want to thank Claire Roller and the Journal of Business and Technology Law for organizing this fantastic symposium. Second, I want to thank our distinguished panelists and moderators for participating in this lively and exceedingly relevant discussion about social media. As we've heard today, issues of free speech, fair use, and privacy on the internet don't just affect athletes and artists, but they affect all of us as we navigate using Facebook, Instagram, and Pinterest. It's become clear to me as I listen today that while we group together social media and employment law, social media and intellectual property, social media and sports law, that really the issues are overlapping. Just as a university wants to control an athlete's online presence, an employer wants to prevent trade secrets and confidential information from being disclosed by employees. Artists who make a living producing movies are concerned about protecting their ownership rights in videos that are uploaded to YouTube, just as we grow increasingly concerned about third-party use and access to our vacation photos. There's a delicate balancing act between retaining control over shared content online and protecting First Amendment rights that we hold dear. This balancing act extends to encouraging creativity and expression through online sharing while still protecting the rights of copyright holders. Privacy rights must be balanced with business concerns such as background checks and advertising. It's exciting to be living in Maryland, a frontrunner in enacting laws that prohibit employers from requesting employees and applicants to disclose their usernames and passwords or other personal account information for social networking sites. As it was mentioned, in 2012, Maryland was the first state to pass such a law. But this is just the beginning. We encourage you, our panelists and guests, to continue this conversation. Stay abreast of new developments in the law and get involved in your own state to ensure changes are made and laws are enacted to keep up with this ever-changing online world. Thank you very much, and go O's.